The Bombay High Court, in its order dated April 15, 2024, clarified that the location of a marriage reception cannot become the jurisdiction for a family court unless the couple resides in the same city. The High Court was hearing a wife's plea against a divorce petition filed by her husband at the Bandra Family Court in Mumbai. Now, what was this case all about? Parties got married in June 2015 at Jodhpur in Rajasthan according to Hindu rites and rituals. The wedding reception, however, took place in Mumbai after 4 days. Post the reception, the couple lived in Mumbai at the husband's parents' home for around 10 days, and then both of them migrated to the United States. After living together for 4 years in the US, the couple parted ways and started living away from each other since October 2019. Come August 2020, the husband now initiates a divorce proceeding at the Bandra Family Court in Mumbai on grounds of cruelty by his wife. Subsequently, after 4 months in December 2020, the wife too initiated divorce. In August 2021, the wife also filed a plea in the Bandra Family Court challenging the maintainability of her estranged husband's divorce petition. According to her petition, the Mumbai Family Court did not have the jurisdiction to adjudicate the divorce petition under Section 19 of the Hindu Marriage Act 1955. On the other hand, the husband submitted that the jurisdiction for a matrimonial dispute should be regarded as a place where the couple last resided together, in this case, Mumbai, which was the wife's matrimonial home. Now, the wife's lawyer argued that the divorce petition was not maintainable before the Mumbai court because the actual marriage ceremony was solemnized in Jodhpur, and the wife also contended that both parties have been living in the US while the divorce petitions were initiated from both sides, and thus the matter should be rejected by the Mumbai Family Court. However, the family court in Bandra had admitted the husband's divorce plea, and thus the wife challenged this in the Bombay High Court. So what were the findings of the Bombay High Court? Justice Rajesh Patil agreed with the wife's arguments and upheld her contention that indeed a Mumbai Family Court could not decide the matter in this case. Justice Patil went on to observe that in his view, there can't be any doubt that the wedding reception cannot become a part of the marriage ritual. To this, Justice Patil said that the last residing place together for the couple would be the US, and it cannot be Mumbai, where the couple briefly stayed for less than 10 days immediately after marriage. Hence, the family court in Mumbai will not have any jurisdiction under subsection 3 of 19 of the Hindu Marriage Act to entertain this divorce petition. Accordingly, this matter was ordered in favor of the wife. Now, let us understand what are the parameters under which a jurisdiction can be decided under section 19 of the Hindu Marriage Act. The Act says that the jurisdiction could be where the marriage was solemnized, or the respondent at the time of the presentation of the petition resides, or the parties to the marriage resided last together. In this case, if the wife or the petitioner, where she is residing on the date of presentation of the particular petition. So what is our take in this case? Ideally, parties must approach local courts where the couple resides or resided together. It is only practical for local authorities, including the police, to investigate any matrimonial disputes or alleged domestic violence, since the evidence witnesses could be examined on ground. In our opinion, the Bombay High Court has rightly directed the matter to a local court in the US. However, this does not deter the wife to return to India and file a case at a court in Jodhpur where the marriage ceremony had been solemnized. There are numerous cases where NRI wives have lived abroad for multiple years, but they choose to return to India, abducting their children without the knowledge of husbands, and then take shelter under a completely lopsided system that allows them the liberty to arm twist their estranged spouses. The jurisdiction location advantage is also extended to non-working wives residing in India who return to their parental home in a different city and then harass their estranged working husbands to travel thousands of kilometers for years on multiple date after date at courts. There is nothing like equality in real terms. A wife in a matrimonial dispute is presumed to be the weaker sex by default as per law, and thus, even if the husband has faced domestic abuse and violence himself in his marriage, it is only and only him who has to suffer more in the hope of expecting justice. Lastly, one may also note that in this particular case, it has taken nearly 3 years for the High Court only to decide on the jurisdiction of the family court, and this gives us an indicator how a contested divorce case runs for decades in our current system. What are your thoughts in this case? Do leave the comments below, and you can like, share, subscribe so that these videos can reach more and more people. You can also subscribe to Voice for Men India, hit that bell icon so that you can be updated as in how we broadcast our new video. You can read the entire order of this particular case in the description link below or on voiceformenindia.com. Lastly, you can also follow us on our social media handles, which is X, Twitter, which was formerly Twitter, Instagram, Telegram, Facebook. The ID is @voiceformenin. That's it from me as of now. Thank you very much for watching. Namaste. Jai Hind.